So,
good morning, members. We have a quorum. The meeting is now called to order. Please invite officials into the room. We have to deal with two papers. The response of the administration to the deputations in respect of the safe harbour, and also the letter given by Mr. Wong Yuk-man, which is also related to the safe harbour. The other paper is on derogatory treatment. I just want to remind you that the next meeting is 23rd of June at 8:30 p.m. 8:30 a.m. Also a Tuesday. May I welcome Mr. Wong and also his colleagues for attending the meeting. Mr. Wong, is there anything outstanding apart from these three papers? Yes, Chairman, we have three papers for discussion. They are to respond to certain questions. Last time, quite a large number of members asked us what are the outstanding issues. There are two. First, concerning the TV stations, they are concerned about the infringement in the Internet. We have to clarify this. The second point is in respect of contract and copyright, the relationship between them, and is there a need for a specific provision to deal with that? We are now preparing the papers, and we hope that we can discuss that at the next meeting. Yes, next meeting is 23rd. Please give us the papers as soon as possible. Please introduce the paper. Let us deal with paper 8 to 9 first. Thank you, Chairman. In fact, there are three papers in response to the comments of the deputations. This is the last one. This is about the safe harbour. First, the limitation on the legal liability of the Internet service providers. The Internet providers are to provide a platform to their users. And there should be limitation to the liability, or limits to the liability of the ISPs. The copyright owners or holders are of the view that it may be too lenient. There should be a graded response in respect of combating infringers, and those who cannot comply with the safe harbour conditions may be deemed to be authorizing the infringement. Now we want to spell out that this response mechanism is a reference to the safe harbour mechanism of overseas countries, and we want to introduce a system that can balance the parts of the interests of the stakeholders. And we don't believe that not complying with the conditions will be deemed to be authorizing the infringement. We spell out the factors under the circumstances where the court can decide. As for the users, their concern is whether this will become a kind of white terror. The ISPs will just remove any alleged infringing materials which are in fact not infringing materials. There are different safeguards in the safe harbor provisions. Say the ISP does not need to monitor the platform. As long as it complies with conditions, it can be given the safe harbor protection. When there is an infringement notice or draft infringement notice. Any misrepresentation is will lead to legal liability. And if a service provider has received such an infringement notice, the service provider does not need to provide the personal information of the users. This is to give a greater protection to the users, so that their identity, there will not be any unreasonable liability imposed on the users. We believe the present approach is appropriate. Another concern is about the code of practice, and we referred to this at the last meeting. There will be a code of practice provided to the internet service providers, and if they comply voluntarily, they will have fulfilled the due diligence requirement. The respondents asked, or the deputations asked, whether that can be a piece of subsidiary legislation, and what is the current situation in respect of code of practice. We've already explained that a code of practice is a voluntary code. Service providers having received infringement notice will take certain action to protect the interests of copyright owners and balance that with the user's rights. At present, the code is not subsidiary legislation. This enables this allows the flexibility so that codes can be reviewed from time to time in the light of technology progress. As for the extent of the code, how far should we go? At the previous the council of the previous term asked us to draft the code ASAP. After 2 rounds of consultation, many views were consolidated. A new version has been provided, and we have attached this new version to you in the paper for you. And we have also met with internet service providers, and they are of the view that they have no specific comments. They think this is a suitable starting point. As for other finer points, whether it should be spelled out that the infringement notice will be made in the form or by electronic means. We don't think the law should go into such details. We'll handle the details in the code to facilitate the users. There is another comment. Whether this will affect or undermine freedom of speech. The ISP will just blindly take away or remove the so-called alleged infringing materials. We ask the service providers, having received a clear infringement notice, will go through certain procedures before removing the materials. After the notice is received, the materials have to be reinstated. As for if a legal process has been instituted by the copyright holder, then the service provider will have the grounds for removing the alleged infringing materials. We believe that is a suitable balance. And finally, it's about protection of privacy. Some deputations said that personal information shouldn't be disclosed to those who issued the infringement notice. But in fact, there is no such provision in the law to require that. The service provider who received the infringement notice has no duty to provide information of the infringer to the copyright owner. the copyright owner can only go to the court to obtain the information of the alleged infringer. This is our usual practice. We have received quite a lot of views in this regard. So the above is the response. I'm happy to take questions.
Thank you very much, DS. Members, in the process of our scrutiny, we have visited this issue of safe harbor many times. This is the response from the administration. And the response for Mr. Wong Yuk-man is even more specific, quoting specific clauses. I'd like to know how you want to deal with these papers. Many of the issues will overlap with the paper. That is a response to Mr. Wong's paper. Mr. Wong, my paper is very long, but your response is not just to me, but also to related views and other issues about safe harbor. I only got the paper yesterday, and I don't know how many members here have read your paper because it's quite rushed. If people have not been paying attention just now, I like to. Now, of course, he will go through your paper in a moment. To me, I also need to study the paper. I also have this long response, but to save time, I can be brief. However, if other members have not read the paper, well, we can't help it. This is the way we have our meetings. You only issued the response paper yesterday afternoon, and this morning we already have this meeting, and we don't have time to digest the content. How can we have a discussion? But anyway, the letter was sent by me, and I have read other responses, and I will be brief with my response. Chairman, first, about point 7 in the paper, the administration says to have a safe harbor is to provide extra protection to OSPs so that they do not have to be held responsible monetarily for infringement done on their platforms. My question has not been specifically answered. I asked you about the first time an OSP encounters this problem, and I have said that OSP definition is too wide, like group managers and Facebook operator. Of course, they fit with the definition of OSPs in my view. And also, Facebook page and group managers can also list any member as a manager without getting the consent of the person concerned. In other words, Facebook users can, without knowing it, become a service provider so that he or she will have to face unforeseen legal liability. Now, your response is simple. You say they will have to comply with conditions, and so that they will not have to take up legal liability for infringement acts. But you have not really answered me, and that is Facebook page and group managers. Are they OSPs? If they are, when the bill is carried, there will be a group of people who will become OSPs without knowing it, and they have to comply with the provisions before they can enjoy the protection of safe harbor. I want a specific response from you. On Facebook, anyone can set up a group and become a manager, and then he can also assign it to other people. I myself have a few such pages. DS? Thank you, Mr. Wong. The spirit and also the wording of the safe harbor provision has not been invented by Hong Kong. The US, Singapore, and even Europe have similar arrangements. So the framework, the spirit, and even to an extent the wording are consistent with those countries. Ever since 2006, when we started consultation and then we went on to drafting the bill, we studied overseas enactments very carefully, and the framework is more or less the same. I can understand the worry of Mr. Wong. I'd like to respond again. From a legal point of view, Facebook users, now if we look at how they operate, they can control the expressions on their own pages. So legally speaking, they might become an OSP. But the most important point is, if you are an OSP, there may be a possibility that he can have extra protection to ensure that there will not be liability for infringement for things expressed on their Facebook page. In fact, this is in the interest of the Facebook user. And if we could look at 88 capital B 5B, you can see that if OSPs cannot comply with the requirements of the clause so that he does not enjoy the protection, they still will not have to shoulder extra legal liability. In other words, the legal liability is there, and they will not have to face extra liability just because they cannot comply with the requirements under safe harbor. And also, I will be very brief, but we have limited time. Please do not give long answers. I'm also trying to be very brief. Just answer my question specifically. So you are saying it is possible. This kind of operation mode, given the vast number of Facebook users, well, we are looking at overseas experience. But do you have any case law so that Facebook users can be exempted? No, they are not exempted, but they don't need the protection, because people say if you are a Facebook user, the OSP who is on a higher level will have to take up liability under this clause, because then the users will not have to face the liability. Well, look, there are so many groups on Facebook. If you cannot give me a specific answer, we may be open to liability. Now you tell me there can be exemption, but you are not specific. No, the specific clause is 88 capital B5, so the user will not have to face legal liability. Mr. Wong, I'd like to respond to paras 17 to 19 of the paper. 88 capital B2A Roman 3 says that if OSP know about certain facts or situations, and these facts or situations will unavoidably lead people to a conclusion that there is infringement, then you were practically reasonable must take reasonable steps to control or suppress such infringement acts. You call this a red flag test. And this will include subjective and objective elements. And what are the subjective elements? You have to make a judgment as to whether the OSP subjectively knows about such facts and situations. And also, the OSPs do not have to proactively monitor or look for such infringement activities. And also, with regard to an infringement act, we have to evaluate whether OSPs know about such infringement according to 88B2A Roman 2 or Roman 3. I'd like to ask you about 88B4, and that is invalidity notice. In other words, if they do not comply with 88 capital C 2 and 3. This is the first question. If someone does not issue a notice through the so-called alleged infringement notice, then will it become an invalid alleged infringement notice? Please answer briefly. The first question, the alleged infringement notice, well, it has to be done according to the stated or specified format, or else it will become invalid. And also the second question, if you do not make use of the specified infringement notice format, the OSPs do not have to mind about it. In other words, this will not amount to liability. In my paper, I quoted an example, but you did not respond to me. That example was supposing there is a surface platform, and objectively, there will be some infringing material in the eyes of certain people, and people may browse such material, and there may be non-copyright owners who will issue notice through other channels, and according to the record, the OSPs have looked at that notice. Then does it mean that that will amount to OSPs making a subjective or objective judgment that there is or should be a conclusion that there is infringement? It's very long and winding, but that is the safe harbor provision. It is usually quite long and difficult to understand even in overseas examples. Let me try to explain. If you receive infringement notices, as Mr. Wong was asking, if a copyright owner issues it, but then it is not in the specified format, and if it is not a qualified notice, then you don't have to mind it. But then there are other objective facts and objective standards which may point to infringing materials appearing on the surface platform. Now, if that's the case, the OSPs will still have to take responsibility to take reasonable measures. In other words, apart from receiving valid notices, there may be objective facts which unavoidably will cause you to know that there is infringement act subjectively or objectively, and you cannot neglect that. The intent of the legislation is to prevent a situation where people know something has happened, but then they choose subjectively not to notice it. And we are saying that they have the responsibility to take reasonable measures. You have a sentence carrying 44 Chinese characters. You read it and you will be short of breath. But then you are actually adding responsibilities to OSPs when they browse their own platforms and read notices. At the same time, they have to vet and also judge whether on his platform there is the unavoidable appearance of infringing materials in the eyes of certain parties. No. In our clause, we say OSPs don't have the responsibility to do subjective patrol on the net like internet police, because we don't want to exert extra burden on the OSPs. However, if in their daily use they discover such material, they cannot choose not to mind it. But this is not a proactive responsibility. Well, I can see something and I can say subjectively I don't think it's a problem. I think the central thought is that you don't have to do this proactively. But if there is a complaint or a report, then you have to do something. Last point. Para 26 of the paper. You explain the general consensus. You say we have to construe it with common use meaning. And under 88 capital A, standard technical measures, and the general consensus means that there is express and widespread consensus with regard to the technology used by OSPs. And we don't need the absolute recognition or acceptance of all copyright owners and OSPs. But how can you come to a conclusion that there is already express or widespread consensus with regard to the use of certain technology? Do you require a 3/4 majority or a 50% majority? What do you mean by consensus and what do you mean by general consensus? Well, I don't think we can apply quantification. Well, so you have to explain to me what you mean by general consensus. What do you mean by some technology being recognized and accepted? I'm trying to help you by quantifying it. Actually, we are saying that within a sector, between copyright owners and OSPs, they need to take some technical measures. We talked about protection of copyright or limiting access, limiting logging in, etc. These are very widely used technologies, and we are saying that within the sector or industry, if copyright owners and OSPs generally know and understand these measures, and if they accept them without resisting them, then this is what we are saying.
It's hard to say that everybody has to agree. Generally speaking, within the trade, the majority accept that. Maybe under the word consensus you can interpret it, but you cannot put it in the law. That's the question. In the law, you have the term general consensus. That's really unclear. And if you are to enforce the law, basing on that, that's really problematic. Now, well, we just follow the U.S. practice. The English version is similar to that. And similar precedents can be a reference in Hong Kong. Therefore, the expression is similar. So what is suitable will be adopted or adapted. Now, after you pass the safe harbor arrangement, if the majority of copyright holders support a certain technology and the majority of the ISPs opposed, then how can you say there's consensus? Just like the pocketed first, the government claims that it's a majority view. Well, it is to be generally accepted both within the ISPs and the copyright owners. Well, I have finished my questions. It's too ambiguous. Any other questions? Mr. Chen Chi-Chin. Now concerning Section 39, they are to protect the Internet users. Here, this provision, Section 88, is to protect the ISPs. The dishonest access to computer can be invoked. Then parody, similarly, the protection under Section 39 will not be effective. Same for Section 88, which is not a good protection to the ISPs. Without the safe harbor offense, where ISPs prosecuted for not exercising due diligence in respect of removing the infringing materials. Let them answer first. We are not aware of such a situation. We said that we will not use that provision to deal with copyright-related matters. We did argue over that, whether they will do that. In the future, if the provision can be flexibly invoked, then the protection provided by safe harbor provisions will be overridden by dishonest access or dishonest access to computer. They said that will not. They say they will not. You don't need to belabor the point. I'm not belaboring the point. My concern is about protection. If somebody if say the DOJ invokes dishonest access to computer to prosecute the ISP, will the ISP be protected under Section 88? It is about copyright. The other is dishonest access to computer. They are two different offenses. I've already made the point. Any other questions from members? If not, we move on to the next paper, which is about the derogatory treatment With regard to the derogatory treatment, that is in response to a discussion at the meeting on the 7th of May. Members asked the administration to provide a paper on derogatory treatment under Section 92, of the ordinance, and we are here to provide the information. Copyright products have two types of rights. Number one, alienable economic rights. That's what we have been talking about. The owner can transfer the copyright in order to obtain economic benefits or financial benefits. There is the inalienable moral rights, which allow authors of literary, dramatic, musical, and artistic works and the directors of films to preserve their relationship with their creation. No one can take away this honor or moral right. This is the moral right which has been established in Hong Kong, and that is the right to object to derogatory treatment. In the Berne Convention, Article 6, bis 1, provides independently the author's economic rights, and even after the transfer of the said rights, the author shall have the right to claim authorship of the work and to object to any distortion, mutilation, or other modification of or other derogatory action in relation to the said work which would be prejudicial to his honor or reputation. And this is the moral rights we refer to. The Berne Convention also recognizes that moral rights include the author's right to be identified as the author or director of his work, and number two, object to any derogatory treatment of his work. That is to maintain the integrity of the product or of the work. The Berne Convention is applicable to Hong Kong. We also have one more provision, and that is, if it is not your, if you are the writer, then other people cannot name it as their own product. There are similar provisions in the copyright laws of other jurisdictions such as Australia, Canada, New Zealand, and the UK. Now, the right to be identified as the author or director, the right to object to derogatory treatment of a work, and the right to have a work falsely attributed to him as author or director are the three rights protected, three kinds of rights protected. This cannot be alienated or transferred. Now, if the moral rights are infringed, the writer or the director can take action through civil action, and this includes the injunction order. Now, for derogatory treatment, there is no criminal offence created. As for treatment, in the UK, the treatment of how they deal with derogatory treatment is the basis of our Section 92. In Hong Kong, there is no precedent, but in the UK, there are precedents for our reference. First, with regard to treatment, there is a provision, which means any addition to, deletion from, or alteration to, or adaptation of the work, but excludes a translation of a literary or dramatic work. If you just translate it, it is not a derogatory treatment or a distortion. That is provided clearly in the law. And what is meant by derogatory treatment? Distortion of a work involves some form of twisting or perversion of it. Mutilation of work involves some form of cutting or destruction so as to render it imperfect. And other modifications of the work may cover any addition to, deletion from, or alteration to, or adaptation of the work which, although not a distortion or mutilation, is nevertheless prejudicial to the honor or reputation of the author or director. we have to consider the relevant precedents. In the UK, they have distilled 7 principles, such that the mere fact that the author or director is himself aggrieved by what has occurred is insufficient to support a claim for derogatory treatment. And number 2, not any treatment of a work is actionable as an infringement of the integrity rights. And also there is a third point, and that is only when the treatment is only when the treatment in question, be it distortion, mutilation, otherwise, is prejudicial to the honor or reputation of the author or director, does it amount to derogatory treatment. So it is not a subjective standard. There must be objective facts to start a legal process. In the UK, according to legal scholars, there can be no breach of the integrity rights without evidence of prejudice to honor or reputation, and it must not be based on subjective impression. In the footnote, we have provided several case laws for reference. This is to establish the principle I mentioned earlier. In Australia, there is another case dealing with derogatory treatment. The applicant is a famous performance artist and the defendant is a famous DJ. There was a cooperation between the respondent and the applicant. A song was ripped and then by the respondent. There was a recording containing words spoken by the applicant. The recording was for other purposes, but not in the song. The respondent put the recording into the song, so that people had the impression that there was a recording of the words as well as the song. The applicant therefore take the respondent to the court. The court is of the view that if people have not heard the song before, people will think that this is part of the original song. There is a disagreement, and the change will harm the reputation of the applicants, and therefore the court ruled that the reputation is harmed, and therefore certain damages are awarded. Now, basing on such, we have already outlined the principles of derogatory treatment in this paper. Thank you. Ms. Ho. I hope the officials can explain the following. With regard to derogatory treatment, is there any objective distinction with satire, parody, and the like? Say if the author or the director feels that it harms their reputation, that will not be allowed. But what about the arrangement of paying tribute to old works, or also mashing up old works? Say, for example, some films have been represented or repackaged through different approaches or means. We've seen that. As for parody or capturing and distortion or changing of the pictures, how do people know that that is derogatory treatment? They don't have any agreement with the author or the director. As for parody similarly, and the like, they are not infringing moral rights. Derogatory treatment must base on this, and that is people have the impression that this will harm the honor, will be prejudicial to the honor or the reputation of the author or the director. As for parodies or similes, they know that this is not the original product or original work, and it is for satirical purpose. Therefore, that will not be prejudicial to this to the honor or reputation. There are relevant factors to be taken into account with regard to parody. Parody or simile, there are clear distinction. People knows that the parody is not coming from the original author or the director.
You quoted a case in Australia with regard to a DJ. I have never been to places with DJs playing records, but I know that this happens. Maybe Mr. Ray Chan can help me out and provide a lengthy explanation. When DJs play plastic records, they may do something to the rhythm and insert even different rhythms and repeat certain chords. If he always does it, then you will know that this has nothing to do with the original record, because in this case, the respondent has included a recording of words, making it seem part of the original song. But if he only plays the record in a certain way and for once or twice, and then people may think that the record is problematic, then what happens? Well, I think we have to know that the Australian case is quite unique. I have already said that actually the DJ and the artist has a partnership, but they fell out. The original recording is actually a recording of the artist, and what you said is quite different. So people who listen to the song for the first time may presume that the altered song was the original song. That is why there will be derogatory treatment. But we can't only look at the altered song. We also have to know that unpleasantness resulted, and the respondent deliberately included this without the consent of the applicant. In other words, there is a problem with the intention, that there may be parody. Of course, people who are in the know, people who have heard the song before will know that there is a mocking of the original applicant. But then those who hear it for the first time may know that the altered song is already the original song. But what if the mocking is not done at a high standard? It will be quite dangerous, right? Well, I have already said that if mocking amounts to parody, then we can't mention them in one breath, because it's quite clear that it is a parody resulting from mocking. But in fact, some people may just want to use a works for a particular expression, and that may not amount to harming the honor or reputation of the author. Mr. Charles Mock, I'd like to make use of the example of Ms. Sid Ho. If DJs play plastic records and they rub the records, would that amount to a kind of performance? And the thing is whether they have paid CASH. We are not talking about republishing the record. If that's not the case, then there is no infringement. Is that right? Now, if you talk about getting a permit or license for public broadcasting, I'm sure all DJs would have got the permission of the author, and this is part of the copyright. But then if you rub the plastic record and change the rhythm at certain chords, then it might change the spirit or style of the original works, and we are talking about the moral rights. In other words, when there is performance, when there is broadcasting, then derogatory treatment can result. Is that right? Ms. Chong, I think the main point about performance is that you should have already got the permission to use the works, and then there will be conditions in that permission. If it is a live performance of a song, if someone does not sing it well, then we can't say that there is harm done to the honor or reputation of the author. So we can't say there is derogatory treatment. You mean there is no case law about performances? Say if someone deliberately sings a song rather in an ugly fashion, then it did not lead to litigation. Is that right? There is no case law in this regard. Any other points, Mr. Ray Chan? When we first looked at derogatory treatment, we were very worried that there might be a clash with parody, satire, caricature, or pastiche. But Ms. Chong, you are telling us today that you can distort the original works. Say, for example, I have written a children's song, but then you changed it, you alter it so that it's full of invective. And then the audience may have the confusion that this is a song written by me. In fact, you had written a song saying a little boy has gone to Guangzhou, but then you have turned it into a song with so much profanity. And if people think that that song was from me, then there will be derogatory treatment. Is that right? Now, of course, now you don't have to rub on a plastic record. You can use apps and you can program it. However, what about getting a recording and including it in a song? Say the recording is just about what he had at lunch today, and then we insert it into the music. So the audience think that the music has included the recording according to the author. Now, would that fall under derogatory treatment, Ms. Chong? The principle is there are three parts if there is derogatory treatment. First of all, that there is distortion or mutilation or modification. Now, there must be such treatment, and so that the author or director will have his honor or reputation prejudiced against. Going back to the children's song, if it is a beautiful children's song, but then it has become a song with a sexual element or undesirable elements, then would that amount to derogatory treatment or distortion? But then, and also the distortion must have something to do with the honor or reputation of the author. Now, just now you said if people will not associate it with the author and people will know that there is a parody and it has nothing to do with the honor or reputation of the original author, then it will not amount to derogatory treatment. And just now you talked about inserting a recording. Regardless of the content of the recording, we don't mind about the content of the recording at all. But if it is inserted into a song or a works, we will look at the overall quality of the resulting works to see whether people will wrongly associate that with the author so that the author's reputation is prejudiced. So we'll look at the overall quality, not the content. Can I add a point? If a children's song, it has become a song with a sexual element and the original singer being a male but now a female sings it, then people know that it is not the original words, then it will not amount to derogatory treatment. However, if I pose as the original singer, and then people will have the misunderstanding that I am singing a song with a sexual element. Well, it depends. If you want to sue for derogatory treatment, finally the court will make a decision and the court will look at relevant case law to see whether such alteration will amount to prejudice to the honor or reputation of the author. So I cannot give you an absolute answer, yes or no, but we can only explain objective standards and the court's guidelines from case law that there has to be distortion, mutilation, and modification so that there is prejudice done to the honor or reputation of the author or director. If we have these elements, then probably the court will say that it amounts to derogatory treatment. Any other questions? Mr. Paul, Chair. Now, this may not be a question related to the present bill. If we look at 92, the definition of treatment. If the works has become distorted or mutilated, and if there is prejudice done to honor or reputation of the author or director, then
work or is otherwise prejudicial to the honor or reputation of the author or director. 嗱，我想澄清一樣嘢咧，就係而家個草擬嘅方式。
I'd like to clarify something. The way you have drafted it has to do with three things: distortion, mutilation, or is otherwise prejudicial. This is a self-containing way of putting it, meaning as long as it is distorted, as long as it is mutilated, and then if in other aspects there is prejudice done to the honor or reputation. So it's a third leg. The prejudice done to honor or reputation is not associated with distortion or mutilation, or is it that the three elements are to be taken together? If we look at the Australian case quoted in the paper,
對唔住嚇，我應該係第五版先啱。第五版
it mentions the Australian Copyright Act 1968, and in Note 11 it says Section 195 capital A capital I provides that the author of the work has a right of integrity of authorship. So it's a different definition from Hong Kong.
The work that is prejudicial to the author's honor or reputation。嗱，佢嗰個定義咧就似乎咧就講得好清楚。
So it's quite clear that whether it be distortion or mutilation or material alteration or anything else which is prejudicial. And if we look at case law, whether there is prejudice seems to be a necessary element. I'd like to know whether in Hong Kong we also have to have this element, that is, that it should objectively prove that there is prejudice, or else there may be a loophole. In other words, there may be mutilation or distortion, and these may not have to be objective. What is your analysis? If I understand Mr. Chair correctly, the three elements, distortion, mutilation, and modification, those may be subjective. However, prejudice must be objective. Well, yes, indeed, because we have copied the UK provision, and we have also looked at the UK case law. And as I said, up to now, we do not have any local case law in this regard. And we have looked at UK case law and also case law in other common law jurisdictions. Those are of reference value to us. So with regard to prejudice, indeed, yes, we need an objective standard. However, now I don't have the English Act with me. You say you have modeled on it, but is it actually the same? It is identical. So the UK case law will directly be relevant to Hong Kong. Now, if that's the case, then under 92B, as I read out just now, the way it is drafted, would there be a loophole? Or do you think it is quite all right? Because I don't know about the English case law. Thank you for the question, Mr. Chair. Indeed, you are very discerning. There is a place where there can be controversy, and that is whether the drafting is already quite clear.
In the UK, they have several case laws. We refer to three cases. with regard to distortion treatment, and also prejudicial to reputation. In a recent case in the UK, there is a slight shift of emphasis. In fact, the provision allows the court to interpret. Do you refer to Delves Broughton? In Note 9, Delves Broughton. Now, if you swap is with otherwise, will that be more? Will that be clearer in reflecting the view? Can you repeat your point?
Mutilation of the work or otherwise， 跟住先至 is prejudicial。instead of 而家講話 or is otherwise。
That is to reverse the word order. The three have to be prejudicial in order to prove the case. Is it a drafting issue? That will make your point clearer. There is no doubt. Yes, we'll look into that. Prejudice is the central element which applies to the previous provision, previous clauses and phrases. Okay, please go back and look at it. All right, if there's no further question, we have dealt with three documents provided by the administration. The administration has always something, and that is in respect of contract, and that's about set-top box, and that's about, and also some CSAs. And also in answering Mr. Wong Yuk-man's question, there is 88B1 and 2. You will make further explanations. You intend to provide to move some CSAs? Do you intend to provide some CSAs? We have been discussing the bill. There are certain proposals for our consideration. There are some drafting issues. Some we have already said will move CSAs, and we are dealing with some outstanding items. We hope that at the next meeting we can report to you where what CSAs we are going to move. Yes, please do it ASAP. Otherwise, Mr. Wong Yuk-man will criticize you for just providing the document on the 11th hour. 11th hour. We still have a few more meetings, but we need to we can see that it's really quite pressing in order to get it through the council endorsed by the council within this session. So you need to be quick in producing your paper, and you need to be precise and brief. Even Mr. Wong is scared by you. By your long-windedness. You're right. We have dealt with all the papers. And then we wait for your other papers. Please come send the papers to us earlier. Ms. Ho. Will they follow the timetable and give notice on the 23rd of June? There will be some amendments, some CSAs, which I will move. And I also want to explain the CSAs at the meeting. So I hope that the administration will provide their CSAs as early as possible. Okay, so be it. The 23rd of June, 8:30 a.m. Okay, today's meeting is adjourned. Okay, we can leave earlier. Please go back and tidy up your work.